Thank you for attending today's March webinar for SPSP. As you can see the title, we're going to be talking about the collaboration and interrelationships between manufacturers and retailers in the safety and quality area, which is kind of a reprise or a new version of the webinar we did last year. And we've got two great speakers who will talk about their thoughts on some of these issues that we maybe talked about last year, but are new ones that we'll talk about this year. First, I want to thank Sedgwick Brand Protection for sponsoring the 2025 webinar series. We always appreciate their contributions, and assistance in providing these webinars to you. Okay. My name is Ken Ross, by the way. I am the webinar coordinator for SPSP, and I'm also a board member. First, I want to do a little housekeeping, talk about future SPSP webinars. Next month, I'm very excited that we are going to finally have a webinar that I've been trying to get the CPSC to speak at for 3 years now. And finally, we've got wonderful speakers who have agreed to answer questions and talk about the areas of both reporting to the CPSC of when you do it, where you do it, how you do it, and also how you develop and implement adequate corrective action programs. The speakers are going to be Blake Rose, and Blake is the director in part for the Fast Track program, and Greg Reyes, who's a supervisory trial attorney, and he will then basically work with the non-fast track kinds of reports and recalls. So we've got two great speakers who will be able to, and I've submitted lots of questions to them, and they're going to pick the questions that they want to answer, and we'll discuss that next month. Then in May, we have talked about recalls many times, but we're going to talk about in May cross-border or international recalls, or recalls with multiple countries, but either here, like Canada, or here in Europe and or elsewhere. And I've got a lawyer from the Cooley Law Firm will be one of the speakers, and Chris Harvey from Sedgwick will be another speaker talking about how we do these things, which if any of you have been involved in those, they're kind of difficult timing-wise and implementation-wise, and they can get very challenging. So we haven't really talked about this part of recalls before. Then in June, we're going to talk about a subject that I love to talk about because it's very interesting and complex and raises all kinds of difficult issues on, what do you do when you have optional safety in a product? How do you decide what's optional, what's mandatory? And then related to that is what happens when you make a safety improvement. And are you required to offer the safety improvement to prior customers? If you can you just put it on new products? And what effect does all this have on both any regulatory issues and also future product liability issues in the event there are accidents? And then another related topic is, because a lot of post-sale safety improvements result from patent applications and the issuance of patents. So what happens with patent applications? So I've got a patent lawyer who's also a product liability lawyer on the panel, and then also Mark Hickok, who's the director or VP of product safety at Milwaukee Tool, is going to also be on the panel to talk about those issues. Then after the June program, will take off until the end of August, and then we'll start in again on webinars for the fall and early winter. Now, one of the programs that I would like to do is on the use of artificial intelligence for product safety. And our friend Alan Abrams from Virginia Tech is going to do a research project on how people think AI could improve product safety. And so you see on this slide that he's looking for research participants for 1-hour interviews on the subject. And we'll be posting these slides. So if you have any interest in talking or have some thoughts that you would like to impart to Alan or his folks, you see the information how you can contact them. So let me introduce the topic to you. And each retailer is different. And we have some that sell national brands. Uh, they sell lots of different branded products, and some of them sell private label products or a combination of them. So some of them are national brands, private label brands. Well, the relationship between retailers and manufacturers can be very different if we're talking uh, products that have the retailer's name on it or products that just have the manufacturer's name on it. Secondly, we also have brick and mortar retailers. And of course, these days we have many online retailers. And so there's really some significant differences in safety and quality and the relationships depending on what, where you are in that area. Now, I would say there's no exactly right way to do this, or there's a lot of wrong ways to do this, and I want to describe a few that I've experienced over the years. Now, I've worked in product liability and product safety for decades, and in my early years, I was an in-house lawyer at a company that made all the Craftsman power tools for Sears. And so I had lots and lots of experience in interrelationships between retailers. And this, because it was Craftsman Tools, it was their name on it. So it was a private label situation. And just let me talk about it, some of the issues that arose both in that relationship and that I've experienced over the years after I left the in-house life. So for example, in the pre-sale area, and I like to divide these between pre-sale and post-sale because in my brain that it makes a lot of sense and from a timing standpoint. So I've had problems where the retailer, particularly in a private label situation, they wanted us to change the design of our product. And even though we considered ourselves the experts in how to make safe products, they wanted us to make changes which we didn't feel would contribute to safety, and they'd make the product less safe. So we had kind of a tension between us and the retailer about changes they wanted us to make and changes we didn't think were appropriate or would add to safety. Similarly, warnings and instructions, maybe we'd have to follow the retailer's guidelines or protocols for instructions, which were different than ours. And they may or may not have been good or not. So we had discussions and some tension about those. Also, retailers doing marketing. And I've had retailers who would market our products and show our product being used unsafely in their advertising. And that's a problem. Now, private labeling is one sense. If it's a national label, that would be a little bit different. Also, in the contracts between the manufacturer and the retailer, many retailers, or most retailers, want the manufacturer to indemnify them in all cases where the retailer gets sued in a product liability case. So when you combine the two, it creates a problem where the retailer wants you to change the design or they market the product showing unsafe use of a product. And then the retailer gets sued because their name's on the product if it's private label. And then they want us to defend them in all these lawsuits. So I had many fights in the old days on the power tool side because we didn't want to indemnify the retailer because we thought the retailer created the safety problem, not our product. So there were a lot of fights that came up on that. Now, the post-sale issue, in the post-sale area, there are also lots of opportunities for problems, and which I've experienced again over the years, where the retailer, for example, would fail to inform us of calls from consumers involving either near misses or actual incidents involving our products until there were a bunch of them, a bunch of calls they had received over a period of time. And the problem was a lot bigger. And if we had known about the problems right when they arose, we could have considered what was going on and tried to figure out if there was anything we needed to do about it. Secondly, the call centers for the retailers uh, didn't get enough information from the calls from consumers, which would allow us to do a post-sale risk assessment, which we wanted to do as soon as possible. Now, I understand and I feel that the job of a retailer is much different and much harder than the manufacturer. I mean, we're selling one product or a couple of products or a group of products, and retailers are selling hundreds or thousands of products. So the involvement of a retailer in product safety issues it can be very difficult because partly in the call center area where the people don't know the product as well as we would know it. And secondly, don't have the time to be quizzing consumers about things that we need to know. So for example, I just had a call yesterday from a new client where they weren't told about problems by a retailer for 3 years. And then they told the manufacturer that they had reported these issues to the CPSC. And then all of a sudden, yesterday, we get a letter from the CPSC asking us for a full report. Well, we'd never heard about the accidents until recently, and we have no information on the accidents. And the information that we're going to be able to receive is very inadequate for us to figure out what's going on. So we're kind of in a pickle about trying to figure out how to respond to the CPSC's request for a full report. So, and then the last thing would be that the retailers fail to adequately assist us in the defense of a product liability case, because again, they've got way more things to do than we have. Now, in my old days involving the power tool situation, probably at any given time, I was defending 100 lawsuits brought against Sears and defending those cases. So we had lots of relationships and lots of issues, and it can be very difficult. So there are a lot of things that come up in this area that can be very difficult. And the best thing I can say about how you avoid them is you want to have a conversation ASAP, right at the beginning or during the relationship before the problems arise as to who has certain responsibilities and what are you going to do in these situations. Now, I have just a couple of slides here, which I'm not going to read through them, but I divide it pre-sale and post-sale. So, and lawyers like to do issue spotting, and that's all I'm doing here. I'm not saying what's right or what's wrong. Now, Rebecca and Tim will give some thoughts on some of these issues, but the question is, here are the things that you ought to be thinking about as you're developing a relationship or modifying a relationship between you and I'm looking at it from the manufacturer's side, not the retailer side, of course. So here are things both on the pre-sale side about design warnings, approval of marketing, contracts, and then on the post-sale side about customer service personnel, uh, when does the manufacturer get in the loop on this information, at the right when these calls come in or at some point afterwards, and what information is obtained by the retailer, or does the retailer customer service person just, have basic questions and then they contact the manufacturer, or they tell the customer to call the manufacturer and provide them the detailed information. So that's something that each company is going to decide. And certainly if a retailer is going to get 100 calls a month about a particular product, that's a whole lot different than if it's one every 6 months. So the answer to these things are basically it depends, which is what lawyers always like to answer. So it really depends on the situation. So that's why I'm just identifying issues that should be considered. Who reports to the CPSC? In my situation yesterday, the retailer reported to the CPSC without telling the manufacturer. They told him afterwards. And so should they have done that, or should we have known about it beforehand? Or should really the manufacturer have reported to the CPSC, not the retailer? So these are questions, again, that you need to think about in developing the relationship that you want to have that makes sense for your situation and the experience that you're having with the product. And then the last two things of who files the report, who decides what corrective action will be undertaken, and what do you do if you have disagreements? And then lastly, the implementation of a corrective action, who's in charge? Does the retailer charge the manufacturer for time and expenses? And how much should that be? And where is it appropriate? And who's responsible for it? These kinds of things. And I'm not even getting into the litigation part of it there. That all could also be part of the contract. So these are just issues that I think are important to think about with no exact answers about what's right or wrong. So that's my introduction to the subject. And I'm going to introduce our speakers and who they're going to take over. And they're going to divide it between pre-sale and post-sale, because I think, again, the issues are a little bit different depending on what they're doing. So first, our first speaker will be Rebeca Sharpe. Rebeca is very experienced in this area, and she's now the Director of Product Compliance and Safety at Best Buy. And then secondly, Tim Urban. And Tim is at BJ's Wholesale Club, Senior Product Development and Quality Program Manager. They're both very experienced in product safety. And I'll just say on their behalf, I guess I'll say it on your behalf, whatever you say today, whatever Rebeca and Tim say today is not an official statement from their companies. These are their thoughts on their experience about what works, maybe what doesn't work, good ideas, or even or maybe some additional things to think about from a manufacturer or retailer side that I didn't even put in my list of issues. So with that said, I am going to turn it over to Rebeca.
Thank you so much, Ken. Can you go back to the pre-sale slide, actually, just so people can see what I'm going to be addressing, and then you can switch it to me if you like. But thank you, everybody, for attending.
Absolutely. Just a second here. I'll do that. Yes. Oh, just a second here. I gotta. There we go. Okay, go ahead.
These are the topics I'm going to address, and I also want to say that there's a different level of responsibility for a retailer depending on whether or not it's a private brand product. Because then for the second bullet point, we are absolutely going to participate in the design, the warning, the instruction, the marketing, because it is our product, and we have that responsibility to make sure that we have an influence over that. The second level would be direct import. If we are directly importing a product, whoever brings that into the country is as responsible as a manufacturer. So we would have more suggestions, more influence over that. Again, we are not the actual manufacturer, but we do have more influence over that to kind of sway how we want that to enter the country or what it looks like when it comes in, because we're ultimately responsible for it. And then certainly for national brands, and that's what I'll spend time talking about in my role as a retailer for mostly national brands. Tim can certainly speak to the pre-sale as far as a manufacturing perspective. He's had a lot of experience with that, with as far as testing documents or letters of guarantee, use, intended use, misuse, that type of thing, and documentation. But there are other things to think about. I think of pre-sale also as before we decide to sell it as a retailer. It might be out there in the market, but what about us? What about us wanting to sell it? So, for example, for new technology, way back when e-bikes were a new thing, and there weren't as many regulations around that, we worked closely with our manufacturers to say, okay, what are the important things that we think you should take a look at pre-sale, for even bringing it into us? The motor, the charging components, brakes, certainly, the battery. And again, this was before it was so highly scrutinized. Another thing is marketing. We certainly take the marketing documentation that retailers or that manufacturers have out there and put it on our website. But there are certain things we're going to look at that they might not see because they're looking at it all the time. For example, we had a baby monitor a while ago that had, beautiful pictures, beautiful ads, baby in the crib, but the cord for the monitor was very close to the side of the crib, within arm's reach of the child. So the product itself might not have any type of flaw in it, but the marketing showed a practice that was not what we would consider up to safety standards with having a cord within a child's reach. Another thing is claims made. And again, we're making suggestions because it's up to their counsel, internal and outside counsel, and what they decide to do. But we've seen a lot of these things, so that's why we're making suggestions. Another one is claims made. You can say things that could push something into a medical device. If it's claims of making you better or curing something. Certainly if it reverses aging. I mean, I'd love to buy that, but I don't know that that's necessarily something you could claim without facts. So just making sure that that's taken a look at. And another thing with children's products, which is again a high risk group, that even comments made on our website could turn it into a children's product. And what I mean by that is we had some earbuds years ago where they were adorable, right? They were a general use product, but the comments said, my 8-year-old loves this. My little kid thinks these are wonderful. Got these for my 11-year-old niece for her birthday. And so even comments like that can push a customer's understanding into thinking it's a children's product. And then that would have a whole different level of testing. So what we did is we communicated to the manufacturer that we were seeing this trend in our comments, and asking them to look or contact their other retailers to see if they were also seeing that. And they actually did the responsible thing and put it through children's product testing to make sure that it was something that was safe no matter what group used it in that respect. So those are some things that sometimes manufacturers don't think about. Or may not think about when they're getting something ready for pre-sale. So that's my perspective on that. And oftentimes we get a lot of good participation. The manufacturer says, thank you for, one more thing that I was going to say too with children's products is showing a child interacting with the product without an adult present. So maybe it's using I've seen pictures of kids with their hands on a washing machine with no adult around. And it's just things like that to keep in mind. So I'll let Tim talk about the other pre-sale aspects of it, which is the testing and well, anything you want to talk about, Tim. So I'll turn to
I'll interrupt before you turn it over to Tim. One other thing that came to mind, and it's only with certain products, and I'm not suggesting that either of you guys, your companies need to do anything like that. But there's certain products where I would say you almost need to train the salespeople, particularly on safety issues, because my experience on my power tool experience is that the salespeople it turned out, they would be telling consumers, when you get this product home, here's how to remove the safety guard and just put it in the corner because it kind of gets in the way. So then the consumer would go do that, they'd get hurt, then they'd sue the retailer. And they, of course, expected us to defend the case and wanted us to indemnify them. And I said, hey, wait a minute, your salesperson is the one that created this safety problem. So to the extent that there are sales, that the salesperson could be making representations or descriptions that could either make it safer or less safe, you should think about that. Now, again, us lawyers, we come up with very impractical solutions sometimes to problems, and that may be very difficult for a retailer to do. But there are certain products where it could be important that the salesperson understands how to describe the product or how it's to be used correctly or not unsafely during the sales process. And to that extent, it would be useful for at least the manufacturer to provide to the retailer kind of talking points for the sales personnel. I'm not sure how hard it is to get it done, but I'm just saying from the manufacturer's side, that might be useful. Okay, I think Rebecca, you were turning it over to Tim. Is that correct?
Yes.
Okay.
Tim, go right ahead.
Go ahead, Tim.
All right, thank you, and thanks again. It's great to be with everybody. I want to reiterate what Ken said before. Anything I share it's my personal opinion. I don't speak on behalf of any retailer or specific group of retailers. I spent side on both the manufacturing side and the retail side. I enjoy both, and I think the key is in the title of this webinar today is the collaboration piece. Whenever I've been part of a relationship between parties that's communicative and understanding of each other and valuing the position of the other group, things just go so much more smoothly than when it's turns into a more conflicting relationship where it's, I want to do things this way, we want to do things this way. That just never seems to be smooth as you execute all the steps. I'm going to talk more specifically about private label or owned brands, as some might call them. And I like to break the pre-sale portions up into the specify period and the verify period. Specify being product development, and then verify being that product execution, which would be the testing and the inspection portion. With my engineering background and product development background, the specify portion is where I want to have all my time spent, so that when we get downstream to verify, and then when we're selling the product and beyond, all the risk as much as possible has been mitigated up front before the first day of production. So the first thing I like to say is always learn the retailer's quality program. So Ken mentioned it before, every retailer has a different program. They have a different team set up. They have different support staff near factories or not near factories. So it's really important to dig in on each individual retailer. What works for retailer A might not necessarily work for retailer B. Those test protocols between the two might not be the same, and there might be a lot of valid reasons for that due to brand guidelines or historic complaints, things like that. So the earlier you can design and move forward with that in mind, the better and more smooth things will be down the road. And then specific to the testing, I've seen a lot of success when that protocol is discussed earlier. So not only what is this product intended to do, which obviously that's why a product or program is this in the first place, but how are we going to test it to verify so that that product development piece is developed with that end testing in mind. We don't want to get to a point where, okay, we're finally testing this product and there's some surprise. There's a requirement maybe someone wasn't aware of. There's a grading or a certification someone wasn't aware of. A component that should maybe be tested earlier on in the process. Just no one wants surprises down the road on any side. So in addition to what's required from a general program requirement perspective, understanding how something's going to be tested is of utmost importance. Other things to think about that maybe aren't top of mind are what are the brand principles or guidelines of this private label brand that you are producing for? Because there might be pieces of that augment your original ideas on how you were going to develop the product, how it was going to be tested. Are there going to be sample reviews with this retailer? Or is the retailer having the manufacturer do all the product development themselves? Some retailers have very extensive teams, engineers, scientists that are very hands-on with product development, and some don't. And both approaches are fine. But again, having worked on that product development side before, just when I review a product and I provide feedback. That needs to be a collaborative moment between and the other way as well. That it just needs to be collaborative. Also, the level of documentation specification a retailer wants to get is basically as much as possible. We want to fill out that specification in a very detailed manner, especially as a retailer. If it's my brand on the product, I need to know everything about it. And the goal here at the end of that specification stage is we've mitigated all design risks, all manufacturing related risks as much as possible. Then we get to the verify stage of pre-sale. Here's where we're talking about testing, component testing, full product testing, inspection requirements. Maybe a retailer has a requirement that a top sample is pulled and sent to the office for review by their team. No one wants that to be a surprise. And what that could potentially mean if feedback is given that wasn't expected. So aligning on that ahead of time is ultra important. And then when it comes to testing, when there's a failure, retailers in general are not inclined to be waiving or overriding test failures, especially if we're talking about safety or regulatory failures. no retailer really wants to override or waive any failures there. It might be considered for a cosmetic type of failure, where as a group, the retailer, holds hands cross-functionally and decides, is this still a commercially viable product or not, based on, the color is a little bit different than we expected. But again, when it comes to something safety related or regulatory related, waiving and overriding is not a path anyone wants to go down. Again, why it's so important to align earlier on how that testing is going to be done. So by the time we get to a lab test, hopefully that's not even the first time that product has gone through certain tests. And then documentation is vitally important from the perspective of a retailer. Being sometimes multiple steps removed from the factory of production, that documentation is really sometimes all a retailer has. So if an issue is to come up, a complaint, the retailer goes to that documentation to find out, information. How was the testing done? Did it pass? What's in the specification? Were changes made that we were not made aware of, etc. So that's my little piece on the pre-sale.
Couple
I'm
of
just going to hop
things.
in and
Oh yeah,
answer
go ahead,
some of these.
Rebecca. Yeah, go ahead.
There's a question in the chat. So I see from Don Mays. Good to see you, Don. Always a pleasure. The question is, as retailers, do you require more rigorous testing than what is required by regulation? If so, who pays for that testing? So I'll just say that as a retailer, I'm not going to tell a manufacturer what to test or how to test. If it's for a national brand, that's their business. It's their lawyers who decide that, their quality engineers. For our private brands, we may just through our protocol, say a robust battery testing protocol, choose to go above and beyond what's just basic regulatory compliance. But again, that's our choice because it's our brand, but I'm not going to be asking a national brand to do something as a retailer. So, okay.
One other thing I was going to raise, and now we're going to do a webinar in the fall on another subject that is very complex, and that is the relationship between component parts suppliers and OEMs. So you can see when we throw a component parts supplier into this, now I got three levels of companies, three different levels: component parts supplier, OEM, and the retailer. Rebecca or Tim, do you guys ever get involved then in the components that your OEM is including in their product? And do you ever look at the testing the component parts supplier does, or do you ever specify a specific component or a manufacturer of a component versus something else? Do you ever get involved in that to that detail, or do you just stick with the finished product? Any of you?
I can jump in, and of course the answer is it varies depending on the retailer and the product type and the brand. I've worked on products in the past where we have designated specific component suppliers for any supplier that was creating a product for our private brand. We wanted the experience by the customer to be consistent, and so for the specific components that were very it had a direct impact on functionality and longevity, we did specify who that supplier was going to be. Also, the percentage of the product that maybe this component supplier is providing, is it a 60% of the end product, or is it 5%? That might be something that a retailer uses to judge how deep they want to get into. But from a retailer's perspective, again, especially if it's private label, which is mostly what I'm speaking to, if there's a change made to my product, I need to know about it because it can affect the product itself, their performance, hopefully not the safety. But if there's some change that happens, we aren't made aware of it. We start digging into our documentation, like I just said, and we see, this board was 12 millimeters thick for the spec, and then we find out that in the store the board is 9 millimeters thick for some reason. It was changed. Maybe that makes it less strong. Then we definitely have a problem that we need to figure out. Why was this change made? Who made the change? When was it made? Can we even track it if we're using the same product identification number, for example? Again, where the collaboration and communication is really, really important.
Okay, Rebecca, do you have anything to add on it, or?
That's a good answer, Tim. Yes, it depends. And also same. I mean, anytime a product is not meeting spec for our private label, we need to know, and even if it's not a safety issue. So, I mean, that's minimum, is that it is what we expect it to be as far as a component level. If it's not, we have to dig into it. So.
Okay, a question related to what we're talking about. Do most retailers perform their own testing on either national brands or private brands?
Well, national brands, again, we leave that up to the national brands to test their products. We have thousands and thousands of products, so it's not reasonable for a retailer to be testing every single product they sell.
But for your private brand, would you do all testing of all private brands?
Well, all of our private brands are tested, certainly. So,
By you guys, or do you just have the manufacturer test them and you review their test reports?
it's a combination, but I think that third party testing is, again, you're a lawyer, Ken, so I don't know how much I'm supposed to say on this call. I will just say that we have a combination of efforts to make sure that everything is tested and appropriate.
Perfect example.
There
Perfect
you go.
answer. I mean, sorry, perfect answer. All right, let's
Channeling my
move.
internal counsel here. Yeah. Let's go to post sale. And if you
Yeah,
want,
let's
Ken,
move to. All right, let's see. I gotta
yeah, you
change.
can pull down that slide because I've got
Yeah. Okay. There we go. Okay. So
Yeah,
we'll start with Rebecca. Oh well, are we starting? Yeah,
I think
we'll
it's
start
me.
with Rebecca on the post sale stuff. Okay, go ahead.
Sure. So again, I'll be talking about best practices. There's a lot of questions here, but I'm going to take you through the process of, what if we hear about incidents? Ken had mentioned in his introduction that it's important that your call center people are trained. So if they do get, and this could be a call, this could be a comment on a website, it could be an IM. I mean, there's a lot of different ways that information comes in as far as incidents from customers. And our responsibility, again, is to make sure that all of those get filtered to our product compliance department. And we have web scraping tools, we have other forms that people can fill out for incidents. So getting that information is key. And then our customer service agents who deal with most of this are trained specifically. There's a section of their script. If they hear keywords or situations, fire, explode gets used a lot, whether or not it really exploded, as you know, if anybody goes through that, cut, hurt, hospital, broken, this kind of thing. They have an option to say, yes, it's a product safety issue. And then that goes into a deeper set of questions to ask to get more information. So again, that is key, not only in the moment to see what happened, but also for follow-up either by our product safety team or the manufacturer. Certainly, we want to get as much as possible. And also, not everything is going to be flagged through that. So that's where AI, we were talking about that earlier, comes in. So we do a web scraping or AI scraping of everything that comes in to look for those keywords. People call them smoke words. I prefer to call them keywords for obvious reasons. And then go through that and see if anything triggers us. And again, it's important if you do this type of AI to set up false positives. Amazon Fire TV, right? There's this Dragon Fireball game, or I don't know what it is, but right now, and we were getting a lot of hits for Dragon Fire. So that's the first thing. Now, our team then, or what I should say is best practice, right? Best practice is that you have a regular cadence of going through incidents that raise to the level of concern, right? So it's important to have legal counsel, maybe product compliance, well, for sure, product compliance, customer service, maybe claims. You can't just grab the data. You have to go through it on a regular basis. And what we do for our manufacturers, or again, best practice, I have experience at Best Buy, so that's where my experience is, but I don't speak for Best Buy. So let me just put it that way. Is we want to make sure that every manufacturer knows about every incident that happens. So we send that out on a monthly basis. So a regular cadence of, and we're not taking a look as, should we tell them about this? Does it raise to the level of concern? We send them everything because, as Ken said earlier, if we're having 3 reports and somebody else is having 3 reports, somebody else is having 10 reports, it's important for the manufacturer to get that aggregate to say, okay, this is not just the units we sent here, this is maybe something we should look into. And that also addresses quality. So maybe it's something that was breaking off and it's not dangerous, but it's still something the manufacturer wants to know so they can improve their product. So they don't get returns or bad reviews, and God forbid it gets on Reddit or something like that. So let's see. I'm trying to get through all these or most of these questions before I want to make sure that Tim has plenty of time too. Who decides to report to the CPSC? Well, we need to keep in mind that the retailers also have an obligation, a legal obligation to do reporting. We can't just send everything off to a manufacturer and expect they do it, because if the CPSC starts asking, you know, what did you know? When did you know it? We need to make sure that is something that we're doing when we feel that it rises to the level of reportability. And I know I keep saying this, Ken, as Ken said, but you covered a lot of points in the beginning. We want the manufacturer to know same day when that is being reported. We don't want them to be surprised. We don't want them months later to have the CPSC finding out about it. So they know at the same time that that is reported. And when it gets into deeper questions, if full reports, we don't have that information, right? I mean, that's really the manufacturer who has all the specs and everything on that. Let's see here. And I'm just gonna, it's not on the slide here, but one of the last things is, oh, no, I'm gonna stop there. Tim, take it away.
All right. Wholesale. Yeah, I've got a little bit less to share on this side of things, but just a couple points is that some retailers have programs where they will go into stores and randomly pull product and just test it to make sure that things aren't changing throughout production, because, you know, with all the testing, with all the inspections, you know, that's, you know, you're doing the best you can. But some retailers might have that. It's probably good to be aware of that. So again, the goal is no surprises, right? For anybody through the entire life of a product. And we talked about this already a little bit, but any updates to facilities, production facilities, component suppliers, raw material suppliers, manufacturing methods, or the product itself would ideally be communicated by the vendor, supplier, manufacturer to the retailer, along with why the change was made. That's a very important piece. If you know, speaking for myself, if I hear that a change was made, it sounds like an improvement, I'm going to ask, why was that done? Is there something I don't know about? So again, the open, honest communication is just positive for everybody. Again, they could result in a change of performance, and if an investigation is needed down the road, all our documentation needs to line up. If there is a complaint or something happens that requires an investigation or a CAPA or something like that, just everyone knows this, but speed and level of detail are just extremely important. Retailers, like Rebecca just said, need to make quick decisions sometimes. A lot of retailers, I would say it's common to err on the side of caution. So that's something to be aware of. So all that to say, the more information that a manufacturer can provide to a retailer, the more everyone can work together to make a facts-based, risk-based decision. Because when there's just questions, that's when I say a lot of retailers err on caution. That's usually when that comes into play. And then again, many products are bought year after year after year, ongoing. I would say on some regular basis, yearly, quarterly, you know, every 6 months, go back to that first part that I talked about, learning that quality program for each retailer, because there might be test protocols that have been updated, maybe a new regulation, maybe a new issue that retailer has dealt with a different manufacturer, drove an augmented tweak to the test protocol. Nobody wants to be in a situation where everyone thinks they're fine just moving forward as in the past, and then again another surprise happens. So that would be something that I would recommend, is for everyone to set a regular cadence for reevaluating test protocols, inspection protocols, spec sheet requirements, etc.
Um, Let me throw in my 2 cents on this. Again, I'm looking at it from the manufacturer's side. Um, you know, we'll do an FMEA, we'll do, risk assessment during design. We should know what potential safety failures can occur. We should know what safety critical components are in our product. And we should know what kinds of potential issues we've evaluated in the design of the product. Those kinds of things we ought to pass along to the retailer because here are the things we would like to hear about sooner than later. And here's the information we would need in order to then do our post-sale risk assessment and try to figure out if there's a problem. And Rebecca made a really important point, and that is that we may be selling to multiple retailers. So it's not just you. I mean, maybe some other retailers are having issues. So that the sooner we know about this stuff, and I won't say I'm not because I'm not speaking for all manufacturers, we'd like to have the opportunity to contact the consumer and find out really what happened and really get into detail, the kind of detail that you guys don't want to get into. You don't have time to do that kind of stuff and maybe don't have the expertise. So it would be something I think that's helpful to us to really try to head off safety problems before they turn into bigger problems. So what has happened a lot in my experience, we get, an email from a retailer saying, gee, we've had, 20 phone calls from consumers over the last 3 years. Here, we thought we'd share this information with you. And oh, by the way, we're going to tell the CPSC about it tomorrow. That's not real helpful. We don't want to wait that long. And then I always worry about late reporting and then who's responsible and getting a big fight about should we have known about this earlier or not. And how do we evaluate it when we don't have enough information? So again, the collaboration, as Tim said, is the important part. Let's have a conversation before you have these issues so we know who can best get this information. The post-sale area from a regulatory standpoint and from a product liability standpoint is the most dangerous area. And so if we're missing stuff, if anybody's missing stuff, we're late in getting it, people are getting hurt, lawsuits are being filed, the CPSC wants to fine you for late reporting, we get huge problems. So really this collaboration post-sale is so important. And we're not blaming everybody, we're just trying to work together to figure out who can best get this information and evaluate it so that a rational decision can be made. And and again, if we find out about components breaking, then we want to contact our component supplier and say, the component supplier, they sell to a bunch of companies too. And then maybe the component supplier can tell you, oh yeah, we've been having other similar incidents with other OEMs. So it's really can be fairly complex. So getting the information, evaluating it, and making rational decisions and collaborating at that point is so important. And I'll just say, again, in my 40 some odd years of experience doing this, it's something that people don't spend enough time at and plan for because we're trying to sell products and get products out the door. And so dealing with this pro-sale stuff is kind of depressing anyway to deal with. So, but we really need to pay attention to it because it's so important.
It looks like we do have some
Yeah, a
questions.
couple more
So
questions here. Yeah, go ahead.
I'll answer the easy ones and give Tim the hard ones. So no, there's some that are more manufacturer based, so I'll do that. And I think we got some of these. Do most retailers perform their own testing on the products branded or otherwise? I gave
we did
legal.
that one.
I did the legal. It depends. You did the golden samples. Tim answered that as far as taking things off the shelf and testing them. Let's see, how do retailers approach responsibility for national brand product where we are the importer of record? And again, I touched on this a little bit at the beginning, which was, we have more influence over that. We have all the responsibilities, so we're going to help direct that. But again, it's not.
Rebecca, let me say, I'm not sure if everybody can see the questions.
Oh, okay. It says, how do retailers approach responsibility for national brand product where possession is taken FOB, a foreign country, so the retailer is the importer of record and thus introduces the product into interstate commerce? And again, that we're the direct importer, we have responsibility, but we might ask for documentation for the testing instead of doing the testing or paying for the testing. So there's some different levels of interaction there. And you want to take can you see them, Tim? Do you have them up, or
I can.
should I read them? Okay, go ahead.
Yeah, I'd move on to the next one. Yeah, I would say, let's see, how does buying products from an Asian manufacturer change the manufacturing retailer responsibilities or relationships to prevent product safety problems? I guess my quick answer on that one is nothing should change the responsibilities or relationships for product safety problems. The approach should be the same, no matter where the product's coming from or who is making it. Short answer.
I'll jump in on that one because I've had lots of issues on that. Certainly, there are two differences when you're whether it's Asia or anywhere else, anywhere outside the U.S. Is that particularly in Asia and particularly in China, is that you're never going to get any compensation from any Chinese company unless they have a presence in the U.S. You're not going to get insurance coverage. So it's a bit different depending on the country where it's coming from as to whether you can be protected in the event there is a problem. In that case, you need to do more testing of your own to confirm compliance, confirm safety than you otherwise would from a manufacturer in Canada, for example. So that is a bit different. By the way, before I forget, I'll be posting some articles that I've written on this subject, both call centers, the retailer manufacturer, and a new article that's being published in May on how to protect yourself when you buy products from a foreign country. So that I'll post that article with the slides that we'll post and a link to the video of this. So there are definitely different issues there because you're not going to sue a Chinese company in China. You're never going to get anything out of it. And if you ask the Asian company to give you insurance protection in the US, they'll probably tell you to go take a flying leap. And so you're kind of on your own. So in which case you have to ramp up your product safety testing and analysis and do your own testing. And the other problem comes up, of course, would be that most of the documentation coming from the manufacturer in Asia is probably going to be in Chinese or Japanese or Korean. And can you even read it? That's one thing. And then secondly, and I've had this problem where the CPSC wanted me to translate all the Chinese documentation, testing documentation and everything else to translate it into English because they can't read Chinese. So you got to worry about whether the safety testing and documentation is in the foreign language or will they provide it in English. Okay, let's see. Next question.
I'll do that one. I'll read that one. Does the manufacturer typically have live access to the retailer's customer feedback data? I would really doubt it. Because that is kept in systems that are not accessible externally. But that's why it's important for a retailer to have a regular cadence of submitting information to manufacturers so they know about it, but not access to live data.
Okay. Tim, you want to do the next one? Try it.
I'll read the next one. I don't have the experience to answer it though.
Okay, well, good.
Maybe you guys can
read.
Yeah, I can read. I do have that experience. Yes. How would you suggest retailers provide return comment data to manufacturers? CPSC is putting an emphasis on that kind of data as incidents, and we are being forced to report based on that data rather than actual documented incidents.
I'm not sure if I understand the question because they use the term "we are being forced." Is that the retailer or the manufacturer? I suspect it's the manufacturer. So, Rebecca, do you have any thoughts on that?
I think that maybe that means the reason it was returned. I'm not sure.
Yeah, well, the reason for the return, but it's the CPSC, I'm not sure if I understand that. Sorry, questioner. If you want to try that one again, I don't quite understand it, so we won't guess at what you mean. How do retailers address safety concerns that arise outside the U.S.? Well, the retailers, we're assuming he's a U.S. retailer selling products in the U.S. So would you guys require the manufacturer, let's say they're selling the same product in a foreign country, would you require them to tell you about incidents involved, that occur in a foreign country? Or actually, maybe a better question is, do you want the manufacturer, let's say they sell their product, it's a national brand, and they sell it to 10 retailers. Do you expect the manufacturer to tell you about incidents being caused, or suffered by consumers of other retailers?
To say I've asked that question and no other place has ever had any injuries or any bad things happen. So you can ask,
Yeah.
but no, I don't expect that. I don't expect that from manufacturers.
Well, certainly the manufacturer is responsible to learn about all the problems involving all the retailers. So let's say a retailer tells me about, gee, we've had 5 phone calls about thus and such. A consumer is confused about how to safely use the product, let's say, and they report that to me. Well, now I kind of wonder, are other retailers having the same issue? And I, as a manufacturer, should probably be thinking about contacting my other retailers to see if they're also receiving phone calls from consumers with this who are having the same confusion. I mean, that's where, because different retailers are going to tell us or not tell us about certain things. So I think you are on notice of that. Certainly in a product liability case, the plaintiff's attorney is going to make the point that you ignored a potential safety issue raised by one retailer when you didn't go to the other retailers and ask about similar either near misses or incidents or confusion by the consumer.
Yeah, I just meant that if I asked the manufacturer, hey, are your other retailers seeing incidents? I don't expect that they would give me that answer. So I'm talking about me asking, but yeah,
No,
can I
no,
see?
that's right. But the manufacturer, I think, should be asking that. That's in the best interest of safety. Let's see, a couple more questions here. How do you manage compliance at a high level during major shifts in sourcing due to tariffs?
That's a whole nother webinar. I think that's a different
Yeah.
one.
Yeah, that's kind of.
I mean, I can take that one just high level. Really, my recommendation for the approach is the full due diligence basically starts again at zero, because you're vetting the facilities again, you're vetting the product again, basically, just because it was executed well, in China. If they move it to Indonesia, it's a different factory, different workers, different expertise, different leadership inside the factory. There's just all those factors that can change. So in general, if it were me, and if I own my own retail company, I would do the full due diligence there again.
Yeah. I'm going to take the next one there because I've had this experience. The same product is sold in Europe and the US. There are incidents in the US. What do you do in the US? Did I read that correctly? The issue is in Europe. Yeah, what do you do in the US? Well, the CPSC makes it clear that you have to consider incidents that occur anywhere in the world where that particular product is being sold. Now, this is a difficulty because you've got different thresholds for reporting requirements. So I've situations right now I'm working on where we had incidents in Europe, we had incidents in the US, the same incidents, the same product. The European Product Safety Authority said you don't have to do anything about it. And the CPSC said we had to do something about it. That creates some big issues, particularly if they're product liability cases that you have inconsistent corrective actions from country to country. That plaintiffs' lawyers love inconsistencies with corrective actions because they're going to say that you either didn't care about the Europeans or you didn't care about the Americans or whatever they're going to say. So, but as a reporting responsibility, you have to consider those things when determining whether you have a reporting responsibility in the US, and certainly foreign incidents or near misses or problems outside the US should be part of your risk assessment. But it's very difficult because you talk about not having enough information in the US. Now I've got call centers in Europe or Asia or South America, whatever, getting information. And how do we conglomerate all this information and evaluate post-sale safety? That is really tough to do, but it is something that you need to think about. And I've worked on stuff where we've sold products in 130 countries, and we were trying to figure out how to do warnings and instructions. And that was a trick in itself. It's like nobody wanted to even figure it out because we didn't know what the regulations were. Another question here is a point being made is that that on the reason for a return, and somebody says fire, and I think Rebecca, you made the point. The consumers, when we talk about call centers, the consumers many times will overstate the problem. Every break is a fire or an explosion. I mean, I've had glass that allegedly exploded in somebody's face when all it did was crack. It didn't explode, but they love to use that because they think they're going to be sure to get, their money back or whatever. And the word fire is, of course, should be pretty clear, but I will say that I've had situations where we had a bunch of reports of fires in the particular case I'm thinking of in Japan, and we couldn't figure it out because we didn't have any fires in the US with this particular product. And it turned out it was the translation. The way they translated the word from Japanese to English, it turned out that they translated it as fire, but in Japanese it wasn't really a fire. So a lot of times either it gets lost in the translation or they have an overstatement. And that's the tough part of the call center. You're not going to sit there and quiz the consumer about, was this really a fire? Did you see flames coming out of that product? And those of you who deal with products where there's fires, that is critical to the CPSC. I mean, if something overheats and chars wood, we'll say, that's completely different than if you actually have flames coming out of the product. In 2006, we recalled 12 million laptop computers because we had one incident where a fire came out of the laptop and everybody had to recall their laptops because of a defective battery. But the difference is that it didn't overheat, there was a fire. So you got to be really careful when people throw these words around: explosion, fire, electrocution, shock, these kinds of things. You really got to quiz them if you really want to figure out what's going on. Let me see.
I just want to be respectful of
I'm
people's
sorry,
time.
we got to
So-
stop. I'm just seeing I'm 2 minutes over here. Anyway, I apologize for going over. Thank you, Rebecca. Thank you, Tim. Thank you all for your good questions. We got more than I thought we were going to, so hopefully we didn't jam that in there too quickly. We will be posting, let me go right here, right here. We'll be posting slides on the SPSP website, some articles, a link to the webinar for somebody who wants to watch it later. And so this slide will be there also. So thank you all very much for attending today. And hopefully we answered most of your questions. And thank you all for attending. Thank you, Tim. Thank you, Rebecca. Appreciate it. Okay.
Absolutely. Thank you.
We'll say
Thank you.
goodbye for today. Thank you all.
Bye-bye.
Bye-bye now.
Take care.
Bye.